Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. I get a lot of questions about the complaint. And one of the questions I want to deal with today is how many times can the plaintiff amend their complaint? There really is no set number of times that a plaintiff can amend the complaint. However, the court should freely give leave when justice so requires. So let's see what that looks like. A plaintiff may amend its pleading or its complaint once as a matter of course within 21 days after serving it on the defendant. Now, matter of course. And what that is saying is that the plaintiff can amend the complaint without having to get consent from opposing counsel or without having to file a motion for leave to amend the complaint, or 21 days after the defendant serves an answer to the complaint. Federal Rules Civil Procedure 15A 1B. Or 21 days after service of a motion under Rule 12B, Rule 12E, or Rule 12F, whichever is earlier. And that's in Federal Rule Civil Procedure 15A 1B. The 12B motion, of course, is the motion to dismiss. The 12E motion is the motion for a more definite statement. And the 12F motion is a motion to strike. Now, any amendment beyond these timelines must require the consent of opposing counsel, or the plaintiff must file a motion for leave to amend. Now, the plaintiff wants to contact opposing counsel to get their consent to amend. If opposing counsel consents, then it would be an unopposed motion for leave to amend. Of course, if opposing counsel does not consent, then plaintiff would just file a motion for leave to amend. Let's look at reasons for amending. And now we're getting into as justice so requires. And one reason is to correct facts. Sometimes we just inadvertently leave facts out. The amendment would allow the plaintiff to include those facts, and particularly if those facts are relevant and material to the case, the plaintiff would want to amend the complaint to include those facts. Another reason is to include additional claims, but the plaintiff must be careful here because the additional claim must relate back to the date of the original complaint. In other words, the new claims or additional claims must arise out of the conduct, the transactions, or occurrence that the plaintiff set forth in the original complaint. Because if the additional claims do not relate back, then there is a statute of limitations problem. Another reason is to add additional parties to the lawsuit. Now, the addition must not be to the detriment or prejudice to the party or parties the plaintiff want to add to the lawsuit. The party or parties must receive notice of the lawsuit. The party or parties would know or should have reasonably known they would be brought into the lawsuit. Additionally, the relations back doctrine is applicable. to add an additional request for relief. Let's say the plaintiff left out punitive damages, and the jurisdiction in which the lawsuit is filed allows for punitive damages. Well, it's critical that the complaint includes that as a relief, particularly when the facts and the law supports the plaintiff's case. To clear up inadequate claims. And we see this when the defendant files the motion for summary judgment for failure to state a claim. The plaintiff wants to amend to cure any deficiencies where they can more sufficiently allege a claim for relief. And that is done through the amendment. Listen, don't be intimidated about asking the court to permit you to amend the complaint. Be confident, and you will if the facts and the law support you. I trust this has been helpful to you. And until next time, be empowered.